Utah's new self-defense law put to the test. Today, a felony weapons case was thrown out despite evidence a judge found troubling. The KSL investigators first revealed the new law's unintended consequences months ago. Now tonight, Daniela Rivera joins us to explain how it worked in one man's favor after he urged lawmakers to pass it. Daniela?
Well, House Bill 227 went into effect last year. Today, a Utah judge said the new law tied his hands in a case he believes should have been presented to a jury. November 2019, a dash camera recorded audio of John Michael Clara firing 7 shots toward a blue truck with a snowplow that had crashed into Clara's vehicle, spun it around, and kept driving. Clara says he was acting in self-defense. He says he saw brake lights and the truck started to turn right.
I was just aiming, to let him know if you come back this way, you're going to get shot.
Under House Bill 227, Utah's new self-defense law, Clara was able to ask for a pretrial hearing to determine whether his actions were justified. And the law shifts the burden to prosecutors to prove Clara clearly was not acting in self-defense or the defense of others. The prosecutor in this case argued Clara was not in imminent danger by the time he started shooting.
These were shots fired because of adrenaline and because he was upset. This was a bad traffic accident.
One of the bullets flew through the cab of a different truck stopped nearby where a man, his wife, and his 12-year-old daughter were waiting for a train to pass.
I observed that she had glass in her hair.
Frankly, if this kind of behavior is allowed and legally justifiable, then we're living in the Thunderdome with Mad Max.
Clara's attorney argued where the bullets actually end up is irrelevant.
It's unfortunate that it hit someone else rather than that target. But if it's self-defense, then that would extend to whatever vehicle it hit.
This case is, in the court's view, a classic case that should be decided by a jury.
Judge Todd Shaughnessy said he found evidence in the case troubling.
As much as it troubles me to hear a story about a young child who was almost killed in the backseat of their car as they're traveling down the street, my hands are tied by the requirements that the legislature imposed in the new statute.
He urged prosecutors to appeal the decision, essentially believing the new law forced him into a controversial ruling.
I believe my hands are tied, and I have no choice, given the statute, but to dismiss the case.
Republican Representative Carrie Ann Lisenby sponsored House Bill 227, and in response to concerns about the new law, she said rulings like the one today can be appealed. However, prosecutors are at the mercy of the Attorney General's office, the only agency that can file appeals in felony cases, and they have just 30 days to do so. If there's something you'd like the KSL investigators to look into, call or text us at the number on your screen, 385-707-6153.